Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
By one estimate, there are now over 100,000 federal employees currently on paid administrative leave. Some took the deferred resignation option offered early in the Trump administration, but about half were put on administrative leave involuntarily. Public Employees for Environmental Responsibility has filed with the Office of Special Counsel, claiming that administrative leave status was imposed illegally. Here with more on their argument and its status is Peer's Senior Counsel, Peter Jenkins. Mr. Jenkins, thanks for joining me.
Thanks for having me, Terry.
Well, you have filed on behalf of Peer a request that the Office of Special Counsel examine the application of paid administrative leave and how that's playing out. Let's start by having you tell us a little bit about why you think that the current process is actually illegal.
Okay, well, we're happy to, and we have done a number of administrative steps and legal steps to try to make this argument, not just with the Office of Special Counsel, but also I should point out that we've filed friend of the court briefs in some of the ongoing cases, and we'll be filing some more. But Congress passed the Administrative Leave Act in 2016 with the express purpose of sort of reining in what was a loose and uncontrolled practice by agencies of how they administered administrative leave and how long people were allowed to stay on and what was the role of investigations and so on and so forth. And Congress made it really clear in that law in 2016 that administrative leave was to be used very sparingly, typically not for more than one day at a time, and for no more than 10 work days within one calendar year. There were no exceptions to that. The other types of leave constitute sort of the other ways in which people can be put on longer leave than those 10 work days. And the most important one of those is investigative leave, where, for a good reason, some agency has a reason to investigate whether the employee did something illegal or, has to be removed for some other reason from the office. But we're not talking about investigative leave now, because that's not what's being used by the Trump administration at all on anyone, as far as we know. It's all under this rubric of administrative leave, and it's all illegal if it's gone on for more than 10 work days in a calendar year. So the problem really stems from the fact that, unfortunately, the Office of Personnel Management sort of oversees the interpretation of the Administrative Leave Act. And the Biden administration, in its final months, unfortunately, left a bit of an opening in its final rule that interpreted that act, its final regulation that interpreted the Administrative Leave Act to imply that agencies could use administrative leave more generally for other reasons and not be limited by the 10 workday maximum. Now, that was not meant to open it up in the way that the Trump administration then jumped in and started just imposing it en masse, across tens of thousands of probationary employees or DEI people or people proposed for a reduction in force or RIF. And it's been used sweepingly far beyond what was intended by OPM in its final regulation, and far specifically beyond what Congress allowed for in the 2016 Administrative Leave Act.
So I understand you to say that the Trump administration is exploiting a potential loophole that was left in the final regulation.
Right. And it is, and we have argued that regulation is an improper loophole. It was not in compliance with the Administrative Leave Act itself, and that regulation should be struck down to the extent that it's interpreted or can be interpreted to allow this unlimited use of administrative leave the way that it has been done. And of course, people have been stuck on it for 4 months, or, since Trump came into office. Within 2 days, he was putting people on administrative leave. And we have several clients here at Peer who've been on it since February 7th. And so I should say that those clients generally are EPA people who were involved in environmental justice or DEI work. And we know that there's dozens like that just in that category, but that's the specific group that we're working with. But we also know that there are thousands and thousands of other people on administrative leave. So our arguments relate not only to our clients, but also to all those other thousands of people on it.
I'm speaking with Peter Jenkins. He's the Senior Counsel for Public Employees for Environmental Responsibility. What is the personal impact for those folks who are kind of stuck in this limbo status on administrative leave? Financial, professional, can you talk to that?
Well, you know as well as I that it's been horrific and tragic what's happened to people who've gotten these notices saying you can't go back to your office, or if you go, you have a few hours to clear out your stuff and say goodbye to your colleagues. That's it. Those people have been, forced out of their offices, even though they want to work. So, and, the end result has been shuttering of huge agencies like USAID, and Department of Education has been ongoing. And, across agencies, there's just been massive removal of people from the work that they're dedicated to, and illegal removals in many cases, whether it was the probationary employees, and that's still being battled out, or it's the people proposed for RIFs who have been put on administrative leave, even though the RIFs have been found by the courts in California in an injunction applied nationwide to stop those RIFs from moving forward. But what are the impacts, on our clients? We've talked to them. They're, personally just extremely frustrated. They've been sitting at home for 4 months, not allowed to work, not allowed to access any of their emails. And of course, they're not even able to apply for other openings within their agency. That's been a huge bone of contention, that, just because you're on administrative leave should not mean that you can't transfer to another position or, apply for other jobs that open up. And so we've fought hard with the Office of Special Counsel and others to try to get them to agree that that is an illegal practice, a prohibited personnel practice, to prevent people on administrative leave from accessing other positions. So a lot of them want to work. They're getting paid generally, but they know it's going to come to an end. And, so many of them, of course, have had to apply for other jobs, knowing that they're likely to be RIFed pretty soon. We'll see what happens with the RIFs, though.
You mentioned, of course, that it's not just folks at EPA that are impacted by this. It's across all of the federal agencies. Have other organizations submitted similar requests to the Office of Special Counsel?
There have been other legal scholars and law professors who have written. There was a good piece in Government Executive about 2 weeks ago by a legal scholar at Stanford that makes exactly the same points that we've been making. Professor Paul Bednar, University of Minnesota Law School, has published commentary pieces. But as far as legal arguments, Peer's kind of been the leader on that. We have been, partly because we've been working on the administrative leave issue for many years because of all the abuses that went back before. It was in prior administrations, back years. And we've had a very prominent client who was stuck on paid administrative leave for 3 years, wow. Literally 3 years, being paid a huge salary to do nothing, and others who've been stuck on excess leave. So we know how harmful and frustrating that is for everybody involved, and a waste of taxpayers' money, by the way. These are people who can work and should be put to work. And Peer, put out a press release a couple weeks ago pointing out that now it appears that well over 100,000 federal employees are on paid administrative leave, including those who took the deferred resignation program, the fork in the road programs. But, roughly 50,000 are people who have just been stuck on administrative leave without taking the deferred resignation. And the sum cost to taxpayers is probably over $1 billion of paying salaries to people who aren't working, which makes no sense at all. And if that's government efficiency, then I'm the man in the moon. Is that government efficiency to pay people huge amounts of money to do nothing?
What are you hearing from the Office of Special Counsel in response to filing?
We used to have good feedback from Office of Special Counsel. We're hopeful that they will pick up. And by the way, what we filed a few days ago was a supplemental memorandum that laid out all the legal arguments, but we had raised the issue to them many weeks earlier, months earlier, in fact. Unfortunately, the Office of Special Counsel has been taken over by a Trump appointee who seems very unlikely to be willing to carry out the mission of the Office of Special Counsel, which is to advocate, on behalf of whistleblowers and to take on these prohibited personnel practices and point out to agencies on behalf of the federal employees that the prohibited practices are illegal and have to be stopped. So we're hopeful that the OSC will do that. Do we have confidence? No, I don't. But we need to make the record. We need to make the point, and that record hopefully will help people too, not just our clients, but others too, who can point to these illegal prohibited practices of leaving them on extended administrative leave, and they should raise those arguments, not with OSC, but in their own separate MSPB appeals, or if they're part of a larger appeal or class, they can continue to raise those issues. That's one part of the overall illegal action that's been taken against them, and they should definitely point that out in their own appeals.
And so what happens next for all of these people who are involuntarily on paid administrative leave?
Well, the involuntary people are mostly ones that are being set up to be RIFed. So it's going to depend on what happens with the big RIF litigation that is now being, it's been fully briefed. It's before the Supreme Court. I wish I was hopeful about a Supreme Court ruling allowing, a Supreme Court ruling on the side of the employees, but I suspect that they won't, but we'll see. We can have hope that there might somehow eke out a 5-4 ruling at the Supreme Court that actually recognizes how illegal the RIF process has been. But for those people who do get RIFed, assuming the Supreme Court allows the RIFs to go forward, then those people who do get RIFed at that point, that they can either raise it in their union grievances if their union members are in a collective bargaining agreement, or they can raise it in their own separate appeals. They can raise the issue of their illegal leave. They should, but eventually, they're not going to be on leave. They're going to lose their pay and they're going to be terminated. But in that point, they're going to have an appeal right.
I've been speaking with Peter Jenkins. He's the Senior Counsel for Public Employees for Environmental Responsibility. Mr. Jenkins, thanks for joining me and for sharing your insight into this really important and very personal issue.
Okay, good. Terry, nice to talk to you.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.